intellectual property law. Is intellectual property law for development and business? We'll find out from William. Welcome, William.
Good afternoon. I occupied the unenviable position of being the last presenter. But thank God, I'm surrounded by a few people that I know. The other unenviable position is standing right in front of such great authorities, and particularly my own lecturer, Tobias. But I hope that it goes well. I have been asked to make it as short as possible, and it will not be a problem, because most of, say everything that I will, more or less give you this afternoon has been mentioned. The only thing that I'm going to do is give it a practitioner's perspective in a nutshell, and then go straight away to look at different jurisdictions and how they have dealt with matters of TK, traditional cultural expressions, or expressions of folklore. I may ask you to join me, this is a joke, I may ask you to join me in a small dance, so be very attentive, because I'll demonstrate a small dance that will kind of remind some of the rugby enthusiasts who may be here this afternoon. Now, when you are a legal practitioner, and I've talked with one or two during lunchtime, definitely the first thing that you do is to receive instructions from your client, and depending on what instructions you have been given, you then automatically look into the legal framework that is available. Now, if you're a patent agent, then our laws here in the country restrict you to filing of a particular patent or a particular trademark. Now, we don't have copyright attorneys. Now, if you are an attorney, which our laws do not provide for in Kenya, then you go a step further in drafting of that patent according to the regulations that have been provided for by the national government that spring from the national laws. Now, those national laws also have to be compliant to TRIPS, which one of our, Professor Sihanya here talked about in passing. Simply because if you're not compliant to TRIPS, and yet we are a member of World Trade Organization, then once again there will be a problem. What then happens when you have a client who claims to be having traditional knowledge? What do? As it is common knowledge that an idea or knowledge cannot be patented. An idea cannot be copyrighted. This particular problem then means that as a patent agent, you then have to once again confine yourself to areas of law of protection of that particular right. Within those laws, it could be copyright, as has already been mentioned. It could be industrial design. It could be, patent. But again, the problem that the indigenous communities or the traditional community owners have is that their rights cannot be effectively protected by the mainstream IP protection. So what then do you do? We have talked about, previous presenters have talked about various options. I remember my own lecturer here talked about orthodox methods, and those tend to be a favorite of different communities, as we shall see in a moment. But apart from that, TRIPS itself also has the so-called TRIPS flexibilities under Article 27.3b, which then provide for that sui generis protection. Luckily, I will not have to explain it again because it had already been explained earlier on. Question for thought? Thank goodness Professor Sihanya has already said that it's a myth, it's impossible that some country has patented echoing. Now, this might also be a repetition in a way, but nevertheless, TK now also has protection. I think we've had 3 various presenters who referred to the specific articles of the Kenyan Constitution. One interesting area, of course, is also provided by NEMA's legal notice, and that is the area of benefit sharing. And of course, policy. I may not have to once again repeat that, but it will come in my conclusion as one of the steps towards coming up with an ultimate bill and also an ultimate, perhaps sui generis protection of traditional knowledge. Of course, given that the Constitution now protects traditional cultural expressions, perhaps if there are authentic, and I repeat authentic, simply because sometimes I could do perhaps the same thing in my own house, but I'm not from that particular community. But as long as there is that authentic nature or authentic origin of those traditional cultural expressions, then it will be possible perhaps to protect the same. Maybe I won't go through that once again. It's Article 11, which protects culture and which is culture and protection of indigenous intellectual property. Maybe some of you who may be familiar with a Luo cultural dance, once again, will be protected. Now, traditional cultural expressions, I did realize my mentor here mentioned that it's actually a struggle in identifying a department perhaps that can effectively deal with genetic resources. Perhaps I haven't gone through the nitty-gritty details of the policy that has been drafted, but that definitely would spring from Article 69, which also protects genetic resources as provided by our Constitution. And of course, you know, a very wonderful example that brings out the biospiritual nature of the knowledge that is that is, so to speak, owned by these communities, as you know, Dr. Marcella mentioned, is that which ultimately protects in not just preserving, but also conserving that particular area, that particular place where such genetic resources either grow in nature. Now, some of the common issues that different jurisdictions have dealt with are not new to our own jurisdiction, and several speakers have actually mentioned them. And maybe here, you know, what spring out is issues of ownership, as in who owns. And thank God, Dr. Marcella put it simply, you know, in a very simple manner when she talked about ownership. Maybe just something that I could mention. The issue of ownership here is also construed by understanding the concept of trusteeship among the community, such that even if an individual is the one who owns, so to speak, a particular indigenous intellectual property good, the understanding within the community is that that particular individual still owns that indigenous intellectual property good in trust for the community. Access and benefit sharing is something else that we will look at. Mine is not really to go through and explain them, but to look at how other jurisdictions have, you know, dealt with these issues. Locus standi really standing, you know, who can sue, you know, who can sue if it is a community. Can the whole community be construed as having locus standi in case of an action? Trusteeship, commercialization, indigenous knowledge systems policies, you know, has been very well explained by previous presenters. You know, I can't forget what Professor Sihanya mentioned about the big P and the small p, where of course we then would rather prefer the big P, you know, politics that informs such making of policies. Biocultural rights and biospiritual virtues, I think this is an area which is totally left out by the, left out and perhaps not fully understood by the mainstream IP, because communities also have that element of biospiritual. When we talk of an evil forest, when we talk of a place that is sacred, it's impossible really, even if such goods were to be commercialized, it would be very difficult to put a price to the biospiritual aspects that come with that particular knowledge from such a community. Sui generis laws, perpetual protection. This is an area again which, TK policy makers love. And of course, TK Commons, which has been fully explained. We'll start with the Republic of South Africa, and we'll really just go through it very quickly, maybe starting with some of the latest developments. Now, this is very recent in that a consortium agreement on indigenous knowledge was signed on the 27th of June, which replaced the contract model. Now, contract model or licensing is an alternative model that is used by these communities in the absence of the other mainstream areas, mainstream methods of protection of IP. The problem is, and I don't want to say that South Africa has perhaps learned from Australia, but we will look at one of the cases where the contract model really didn't work because most of these indigenous communities, yes, I wouldn't say that they are poor because they are rich in the knowledge that they have, or whatever they have is considered to be their wealth. But in terms of modern commerce, they may not be in a position to, for example, access legal representation that can help them in coming up with contracts which can bring out win-win situations. Because the problems have always been that our property is being stolen. You can call it biopiracy. Dr. Tobias said he would rather not use the word piracy. But in most contracts, we find that the agreements leaned more towards people who had access to legal representation and also towards corporates that had the financial muscle. Databank of TK, this was an announcement that was made actually in May, that a data bank now is to be established and to be completed by 2015. Perhaps this is something that Kenya is also trying, and Kenya could follow this example. And this is the role of the Department of Science and Technology. Then there's the IP Amendment Bill. This IP Amendment Bill is a non-patent, is a bill to amend non-patent bills of trademark, copyright, etc., to effectively protect indigenous knowledge. Then, of course, there's the policy. There's the National Environment Management Biodiversity Act, which of course has the features of access and benefit sharing, prior informed consent, and material transfer agreements, which have been well provided for. And these really may come as different terms, but they are also available in our own NEMA Act. How many are unfamiliar with the Hudia? I think that's a very popular example. Then, of course, now there are two competing bills, because in 2012, the TK bill did not succeed to go through Parliament. Now, New Zealand, then, I can say, has taken it to another level in terms of a holistic approach. And very quickly, perhaps some of the features here are that they have made sure that traditional knowledge is not just a knowledge that is relegated at a place and given particular attention, but has been brought into the whole, system of it has been brought in the way of life of the New Zealanders, such that there are language nests where Maori children are taught their language, perhaps up to the age of 6, and they continue on. If they like, they can learn such language and also study in institutions in that particular language right through university. They have also, of course, have protocol that is also seen in several ceremonies. One of the protocols is the Haka ceremonial war dance, which I promise you'll join me in dancing in a moment. Then, of course, they've also contributed the Matauranga, they've contributed the Matatua Declaration on the Culture and Intellectual Property Rights of Indigenous people. So they have New Zealand has upped its game, literally, in their TK. I think I'll have to, how much time do I have? No time at all. Okay, very quickly, perhaps in Australia, maybe a good case is the case of Bulun Bulun versus R&T Textiles. Now, this is actually a case where an individual indigenous artist, painted the famous magpie geese and water lilies at the waterhole. And unknown to him, a textile company, took up this particular case. Took up this particular painting and went and printed it and started making money. Now, when the indigenous people got to know about this, they sued for infringement. And this brings out the peculiar role of trusteeship within the communities. That's why it was held that an individual had a fiduciary duty to the community, even though the work belongs to an individual. I'll skip this one. This one very quickly is in terms of locus standi. Now, this was a musician, and this particular musician decided then to adapt a particular rhythm from the Heze community in China, and he did this without attribution. Now, the problem was who then could sue for the community, and you can see that here it was held that the local government of the Heze actually had the locus standi on the behalf of the community. Sorry, this is actually my last, I think, I hope. Yeah. Panama, now this is a model sui generis law. Now, what's interesting about this law is that now it even captures the biospiritual virtues that we were talking about. Because if you look at it here, you find that it then, it's a special system which protects the TK, TCE's customs, traditions, beliefs, and spirituality. The spirituality element is something that mainstream IP cannot really protect. The other interesting thing about this sui generis law is that it actually fulfills the wishes of the TK policy makers, who have looked for a means of protecting TK perpetually, a means of protecting TK without technicalities, a means of protecting TK in a cheap manner. In fact, if you look at this, a member of a community in Panama, an indigenous community in Panama, does not need even a lawyer to file or to register their rights. And if you look at the revenue generation, 50% here goes to the national treasury, and the other 50% is earmarked for investment expenses of the corresponding indigenous people. This is my last slide. The Alma Mater Declaration is a declaration by the World Health Organization for Africa, which actually encouraged African countries to take seriously the issues of traditional medicine, and that states should do everything possible to assist. Now, the problem perhaps with this declaration is that by the time it was being declared in 1978, some of the conventions that have certain features of, say like the Convention on Biological Diversity, had not been ratified by various states, so it's important that it is revised to reflect the latest trends. Of course, indigenous knowledge system policies be drafted by governments, sui generis laws be legislated, and TK commerce really should be embraced by various stakeholders.